All rise. Court of Appeal in for the Fifth District of the State of Florida is now in session. The Honorable J.P. Cohen, Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the Fifth District Court of Appeal. I've been introduced. The other members of the panel to my right, Judge Brian Lambert out of Ocala, out of Marion County. And we are honored today to have Judge Robin Lemonitis, who is a circuit judge from Brevard County, who was going to sit as an associate judge this week on the court. If any of you have any electronic devices or anything that makes any noise, if you'd please make sure to put them on silent or either to turn them off. That way we won't interrupt the flow of the attorney's arguments. We've got a number of cases set this morning. First is a criminal case. The remaining cases are civil. In the criminal case, both sides will be entitled up to 15 minutes each for their arguments. In the civil cases, both sides will be entitled up to 20 minutes each for their arguments. If you would like some time reserved for rebuttal, please let me know. I tend to do a default of 5 minutes for rebuttal, but you can alter that any way that you prefer. So that said, the first case on the docket is Greenwich versus State of Florida.
Hey, police court. My name is Ed Weiss. I'm here on behalf of the appellant, and I pronounce it Mr. Greenwich. I don't know if that's correct or not. Mr. Greenwich was convicted of second-degree murder of his fiancée. We're here. I want to discuss predominantly just issue 1, the invocation of his right to counsel under Article 1, Section 9. It's something this court has not written about. It is something that the Florida Supreme Court once again recently wrote again in McAdams v. State. I want to also state up front, I've watched the video in this case multiple times. There are 2 versions of the video at the court. In my brief, I went to the timestamp of how far into the video. Upon rewatching, there's different versions. So if I ever refer to the video in oral argument, I'm going to refer to the actual time on the video that's showing by the PM.
Let's assume that we agree with your position that McAdams is really dispositive of many of the issues in this case. Much of the comments, much of the statements made by the defendant. At some point in time, the stepfather is able to get in touch with
it is after the
defendant.
The admission to an accident.
And according to his testimony at the hearing, he advised the defendant to exercise his right to remain silent.
Correct.
Subsequent to that, the defendant makes certain statements. Those statements were not as a result of questioning. They were simply voluntary statements made by the defendant. Why are those statements not admissible?
I would argue those are not admissible because the damage is already done. The cat's already out of the bag. It's just like if after he's advised not to speak, he continues to speak. Had that advice been given prior to any of that stuff, and had the officers had allowed him contact with his stepfather, who was the attorney, he would have known not to say anything. But by the time he talked to his stepfather...
He did know. He was aware at that point in time not to say anything.
Correct.
He had been advised, so the damage of not giving him access to counsel at that point then is cured. They give him access
Well, I would argue it doesn't exactly cure it. I mean, you're
It
talking,
cures it if we suppress the statements that he made.
in that regard, yes. However, you're asking for someone who may have a high school education, who doesn't practice law, to understand
Would it make a
that.
difference if he was a college law professor?
I think it makes a difference if he has a better understanding, but we're taking someone who is an apprentice as a steel worker and expecting him to understand the constitutional ramifications and understanding, okay, although I said it then, hey, this is going to be a violation, that's eventually going to get suppressed, I need to keep my mouth shut.
Stepfather is a lawyer telling him, okay, dummy up, in essence, and the guy keeps talking. Why? Yeah, that seems to be a voluntary choice at that point by him to do that, and why doesn't that come in?
Again, I think because the cat's out of the bag, it's fruit of the poisonous tree. But for that initial stuff, there's no break, there's no time difference, there's no
questioning,
location
though.
difference.
But there's no government action at that point in time. There's no questioning of him. You know, it's one thing if, you know, they continue to question him, you know, after he's exercised his rights, invoked his rights. But here, there's no government action. It's just he volunteering certain statements.
And again, I realize that they didn't ask him any questions, but they kept him in the room. If the interview was truly over and they weren't trying to obtain more information, why not right away escort him out, leave the room?
Well, how long did they keep him in the room? And is there any evidence that they kept him in the room with the intent to secure additional information from him?
I can't say if there was no evidence presented because that was never questioned at the hearing.
Didn't the officers terminate the interview themselves? Mr. Greenwich didn't terminate the interview, did he?
Once they obtained their confession as to the accident, they took it upon themselves to dial the phone, even though the defendant had asked for over a half an hour to contact his mother. That's when they finally took it on their own. They got the statement they wanted, and they dialed the phone and handed it to him. Yes, that's how that ended.
But then the statements, as Judge Cohen says, that he made afterwards could be characterized as just a rant, where he was just repeating, I tripped and killed my baby, I tripped and killed my baby. How is that anything but a spontaneous statement, not prompted by government action?
It is spontaneous. However, my point of why I think it is prompted by government action is he had been in that room since 8, 9 o'clock in the morning. The interview had been going on for over 4 hours. For over 4 hours, he's been denied his counsel. He's been denied an opportunity to call his mother. He's been inundated with them telling him he's lying. He finally buys into what they suggest as an
Oh,
accident.
he was lying.
Depending on how you, that's what the jury
he
said.
said he was lying.
From your perspective, wasn't he lying?
I don't think he was being completely honest on
Oh,
everything.
come on,
But they-
we don't need to mince words, he was
Yeah.
lying.
They were
wasn't he?
inconsistent exculpatory statements, weren't they?
They were absolutely inconsistent, and unfortunately, for my client, you did have the security guards that said, yes, we called it in.
Can
So
you
those
give me
things,
the difference between absolutely inconsistent and lying? I'm just missing this distinction.
I mean, he
Lying.
lied about, I'm not going to
Okay.
deny, he lied about the
Okay, all
security
right,
guards.
then say that. You were
Absolutely.
denying it, but that's
No,
okay.
I
So-
admit that.
All right, so he was lying, then they finally break him down.
But you have a man who's been in custody indisputably since approximately 5:30 in the morning. It's very clear on the record, he was put in handcuffs and in the back of a patrol car shortly after Officer Bridges arrived because he was interfering with their ability to render aid. He's been in custody with his hands cuffed behind the back in a patrol car for hours. Then he's taken and he's left in an interview room by himself for hours. Then he's in that same interview room. It's not until almost 12 hours after he's been arrested. Anyone in that situation is going to be broken down, whether or not they ask him a question. After that, he's so broken down, I don't think that's subject to without government action. The government has withheld him and isolated him for almost 12 hours. They finally break him down, even though he's repeatedly asking to make the phone call. They wait until after the
Well, he's calling, he
confession.
wants to call his mommy. It's not like he's asking to call a lawyer, he's
Oh,
saying call mommy.
I admit to that, he's asking to call his mother. Now, at the testimony, I believe he did say he was asking to call his mother to get a hold of his stepfather. Well, I don't really think the trial court found that to be credible. He doesn't
Well,
come
for
out
good
and say
reason,
that.
because he's not really a credible,
What's that?
he's not a very credible fellow, is he?
No, he's not.
Okay, so the trial judge, within his discretion, made their call, and trial
But he
judge also
never-
said it was a voluntary, that the statements made by Mr. Greenwich were voluntary, wasn't it?
The trial court found as per Miranda, on the waiver of Miranda, where trial counsel tried to allege that he was under the influence and wasn't a freely and voluntary waiver of Miranda.
But
The trial
wasn't
court
there
also found that
evidence-
Halliburton didn't apply because this case did not involve intentional concealment.
But didn't the evidence didn't the record show that he was not under the influence? There was no, when the
I
officers
did not
had
raise that for
contacted-
that reason. I'll be honest, upon watching the video,
well, let's-
I didn't raise it for that reason.
And he'd already sat there from 8 AM to 1:28 PM. so-
Again, that is exactly why I did not raise
So is it your position that he was taken into custody shortly after 5 AM, that he was consistently in custody between 5 AM and the time that he was delivered to the
Absolutely.
police department at 8 AM?
That's the testimony. That was the testimony at trial. He was in custody from 5:30 all the way through. He was
Let me
taken.
ask you this.
Yes, sir.
Let's assume that, we were to say, all right, the earlier statements should have been suppressed, but that this later statement is still admissible. He would still be entitled to a new trial, wouldn't he?
Absolutely, I believe so. Because if you suppress all those other statements,
It changes the context.
the inconsistencies that this court says, or the lies that he puts forth, are no longer presented to the jury. That has a big impact on a jury. If you sit there and you have the detectives sitting there saying 4 or 5 times, well, this is version 4, this is version 5, you eliminate that. You eliminate that from a jury.
All right.
And I think
And
absolutely.
then at that point, we can address the pornographic website issue.
Right, if the court has any questions on that, I think it's obvious that the state below, the only evidence to connect the defendant to the phone actually doesn't connect them. There's no testimony in the trial as to who had the phone when the calls were made, and on the video, when he's asked about it multiple times, he says, look, the officers went upstairs to get the phone, they got the asked me for the code to make the call. The last time I saw the phone was when the officer was calling my sister.
Did it have a sticky note on it that said what his Facebook username was?
If I recall correctly, the testimony at the trial was that the Facebook opened, that it didn't have a username and it wasn't logged in, it was just the login page that opened.
Or, no, RJ Easy Wise Guy. Someone manually put in RJ Easy Wise Guy.
I guess my client is very ambidextrous because there's no testimony of anything other than that he was handcuffed behind his back in the back seat of a patrol car. So that's pretty impressive if he was able to do that, handcuffed behind the back, in the back seat of a patrol car.
You don't have children?
Excuse me? I mean,
You're in your rebuttal time.
I only wanted to reserve 3 minutes anyway,
Right,
so
okay.
I apologize for not informing the court. But when it comes down to it, there's no nexus that the defendant had the phone. And the trial court's belief that, well, that's for the jury to decide. Well, by doing that, the trial court failed to do its gatekeeping function of ensuring that only relevant evidence was before the jury.
Well, let's say he had the phone. I mean, how is it relevant anyways?
It's not.
Okay, isn't that
It
your better, is that your better
absolutely-
argument?
It absolutely is not, and
As opposed to saying the cops are the ones that call on the phone, that your guy was on the phone and somehow these websites popped up, but they really have nothing to do with what happened 2 or 3 hours ago.
I absolutely agree with
And the
that.
state's position, it seems like the state's position here at this court differs from their position they took at the trial court as to the reason for the admissibility of that evidence.
And that's exactly what I said in my reply brief. The state's position on appeal is actually
Well,
the
apparently
polar
you've convinced
opposite.
Judge Lambert.
What's that?
Apparently you convinced Judge
Yeah.
Lambert. then.
The argument on appeal is the polar opposite of the argument at trial. If you apply the argument on appeal, there absolutely is no relevance because they concede on appeal that they could not tell when those pages were actually
Could have happened
viewed.
before.
Could have happened a week before, 2 weeks before. There's no relevance whatsoever to these, even if they were viewed after the fact. How is that showing ill will and hatred for second-degree murder? It absolutely does not. So in that regard, no, they're not relevant. And I would like to reserve the final 3 minutes for any potential rebuttal.
All
Thank
right,
you.
very good.
May it please the court, Sam LaProne for the state.
This is a reversal, isn't it?
No.
No. You don't think McAdams is dispositive?
Not in this case, Your Honor.
Why not?
The McAdams decision, the court was very clear with respect to the due process claim that there are two essential requirements. You have to be retained and you have to be available. It means you have to be wherever the defendant is.
Oh, no,
And what-
you know, that's ridiculous.
No?
Why,
not-
you think it makes a difference if, in order to have a right to counsel, that the counsel has to be at the police department where they won't give him access versus trying to get him on the phone? You think that's a legitimate distinction?
Well, whether an attorney is actually, for instance, at a police station and is being kept from the defendant is different from an attorney being in another town.
But why?
If due process has any meaning, why shouldn't a suspect be told that the attorney is trying to contact him, and any attorney is trying to contact him, regardless of whether it's in person or by phone? How does that do justice to due process by denying him that knowledge?
Because in this case, all the evidence related to Mr. Page talking to Detective Gribble and the police receptionist is that he's trying to contact Detective Gribble. He's not trying to contact appellant.
Right, but is it your position that a front desk officer at a police department has no obligation to tell the interviewing detectives that there is an attorney trying to contact the suspect that they're currently questioning?
Well, Mr. Page wasn't able to identify the receptionist. So what we have is a discrepancy between what Detective Gribble got on the, I think it was a Centercom system, from the receptionist that a Mr. Page was trying to contact him and that there was no mention of an
You
attorney.
don't know for sure whether Mr. Page identified himself as an attorney or if the front desk officer just decided to omit that fact.
We don't know that. We have Mr. Page saying that.
right,
But then
and-
but then also we have the trial court who's looking at all this, listening to all the testimony, has Detective Gribble saying, I got a message, but I didn't get a message that he was an attorney, and that
Well,
Mr.
but
Page saying,
that doesn't contradict the stepfather's testimony that I told the front desk receptionist, I'm his lawyer. Now, I'm not just, I am his lawyer. I'm trying to get hold of him. I'm his lawyer. Where in the record is there anything that contradicts that?
well, you have Detective Gribble saying the message that I got.
No, he says,
Well, we don't-
I didn't know, that the comm center didn't tell me that he was a lawyer. That doesn't contradict the testimony from the stepfather that I informed the receptionist that I was his lawyer and wanted to talk to him.
No, it's inconsistent with it, but we don't know who the
Not
reception...
inconsistent.
Well, we don't have the receptionist's name, so there's no way to find out.
Well, whose
Mr.
fault is
Page-
that?
Mr. Page's fault.
Yeah.
Well, but the judge did not make a finding that he didn't believe Mr. Page's testimony when he said that, when they had their suppression hearing. I mean, your argument, I think, would be better that if the judge says, well, this is the testimony that I heard, which he did say when he was making his oral pronouncement, he didn't then make a finding, I reject it, it is not credible, I don't believe he made that statement. Then I think your case would be better that it's simply a father calling on behalf of his son. But since the judge didn't make that finding and Mr. Page's testimony is otherwise unrebutted, clearly the people at the comm center have an obligation to let the detectives know who are doing the interrogation that there's an attorney trying to contact the person they're interrogating. I don't dispute that Detective Gribble may not have been aware that Mr. Page was an attorney, but as I think Judge Cohen and Judge Lemonitis are indicating, that's really not dispositive. Otherwise, you could simply say, okay, just don't ever tell us when there's an attorney on the phone.
And doesn't that begin to smell like willful ignorance on the part of, or obviation on the part of the front desk person?
No, because I think in this case, again, the testimony is fairly consistent that Mr. Page was not trying to contact the defendant.
Well, sure
And this
he
is-
was. I mean, and he was trying to contact his son, but he wanted to know who the detective was because he was aware that there was an interrogation going on, so he wanted to speak to the detective, to probably let the detective know he wanted to talk with his son.
But also, with the voicemail that Detective Gribble had on his phone from Mr. Page testified at the suppression hearing that he didn't leave any particular instructions for Detective Gribble on that voicemail. So if that's his attorney...
He stated
and
that he was an attorney, though.
Wouldn't
And that he
matter
was trying to
anyway.
contact his
But
son.
he also said he's his stepfather.
Wouldn't have mattered. The guy never listened to it. It wouldn't have mattered. He could have given him explicit instructions and it wouldn't have made a whit of difference because he didn't listen to it until after the questioning was already done. how would you distinguish State versus Allen, then, out of the first DCA, in terms of this argument that you got to be present at the police department as opposed to available telephone, trying to contact them telephonically?
Well, I think one of the prime distinctions in this case
How would you distinguish State versus Allen?
from Allen, there's no evidence that Mr. Page was trying to contact the defendant. The only evidence is that he's trying to contact Detective Gribble. Now, he didn't leave a message with the receptionist to say, I'm his attorney, I'm his retained attorney, I want questioning ceased, and he didn't leave that message on the voicemail, despite the fact that...
But here's what the detective says. He says, so after the interview, you checked your voicemail and you believe there was a voicemail there? Yes, if I can recall correctly. Question, do you remember the contents of the voicemail? Answer, he. I believe he was identifying himself as Mr. Page, Mr. Greenwich's stepfather, and that he was an attorney. So that's the voicemail message that the detective left, that was left for the detective, that the detective admittedly did not hear until after the interview concluded. But obviously, if the detective had listened to it during the interview, he was on notice that there's an attorney wanting to...
It's also his stepfather. That's...
What difference does it make?
I don't understand.
I think it's a complete difference because...
So I'm a father, and my wife says, hey, our kid's in jail, and he's at the Marion County Jail, and I call them up, and I say, hey, I'm the father, and I'm an attorney, and I'm on my way, huh?
It's different because you can't represent him. That's the point.
Why not?
If
as a judge...
If a relative of mine is arrested, and I call and say I'm an attorney, I can't represent them because I represent the state of Florida.
Oh, okay,
Right.
all right. My
So
other son, who is an attorney, calls the jail and said, hey, you got my brother there. I'm an attorney. I'm coming to see him. He can represent his brother, can he? He's employed by State Farm. That'll make you feel
And
better.
if he's just there to give him advice, if he's calling and he knows enough Criminal Law 101 to say, stop talking now, why would he not be allowed to communicate with the person who was going to give him proper legal advice?
Well, ultimately, he did talk to him, and the defendant
After the
decided
damage
to...
was done?
I'm sorry?
After the damage was already done?
Well, the damage was pretty much done from the beginning of the
Oh,
interview.
no. Yeah, that's not true. That's just factually not true. At the time that he first called, and talked to the receptionist, there had been no incriminating statements made, at that point in time on this record. I want to go back to the case of the State versus Allen case. Are you familiar with that case?
Briefly, Your Honor.
Okay. The first DCA found that the police violated a suspect's right to counsel by failing to notify the suspect that prior to or during a custodial interrogation, the suspect's attorney had called the police station trying to reach the suspect despite the fact that the attorney was never physically present at the police station. Was that case incorrectly decided? Under your theory, apparently so.
Well, factually, I think that case is different because there's the crucial aspect of he's trying to contact the defendant. He's not trying to contact. Mr. Page could have been contacting Detective Gribble just to find out what's going on.
What do you think that Page was contacting the defendant for, or the detective for, to just find out how his day was going? You don't think that...
I'm assuming he was trying to gather...
You don't think it's a fair assumption that he is, and he testified at the hearing that he would have, he was going to tell the detective that he was the lawyer and to stop questioning the defendant.
But he never said that. He didn't say it when he spoke to him at the interview, and he didn't say it on the
Because they
voicemail.
wouldn't put him through.
But there's no evidence of that. The only evidence is that the voicemail didn't contain that, and when he spoke to Gribble during the interview, he didn't say that to him, even though it was already after the fact.
I just read the testimony from the detective. The voicemail did say, I'm an attorney.
But it didn't give him instructions that I want questioning to stop.
So that's where it tilts right here for you? You've got to make a specific magic word statement to the detective?
Well, you have to give some direction to the officer. Are you invoking his rights?
I'm an attorney, I want to speak with my client.
He didn't say that. He said, I'm an attorney.
And he wanted to speak with the detective because the detective is the person that he really has to tell, stop questioning my client, not his son, who may or may not listen to him.
And in this case, he didn't. He kept talking.
That's his choice to make, though, at the time. But he didn't have that choice to make early on when he made a lot of his inculpatory statements.
But
Wouldn't you agree that an attorney has the right to invoke on behalf of their client?
yes, he does.
You
But
think
this-
that the suspects in police interrogation, that the police let them keep their cell phones with them?
I'm sorry, can you say that
You
again?
think that the police let suspects who they're interrogating keep their cell phones with them in police interrogations?
Not normally. I wouldn't think so.
No, not normally. So who else is he going to contact other than the detective who is doing the questioning?
Well, I think in this case, what is unique is that this is not a retained separate lawyer. This is not someone who is just out there the defendant knows. He knows his
So what?
He knows his stepfather's an attorney, and the only person he wants to talk to is his mother.
Perhaps to engage his stepfather.
Then he should have asked for his stepfather. He knew that they were going to be together.
I don't think, though, that we're focusing on his request to call the mother. I don't think that, at least from my view, that's not significant. What is significant, however, is the stepfather's efforts to contact, the son and through the detective, which is the only way that he's going to be able to contact him. He finds out who's investigating the case, he finds out the name of the detective, and he makes efforts to contact that detective, and at the hearing, he testifies clearly that I was contacting that detective in order to advise my son-in-law, or not son-in-law, my stepson, to not make any statements, stop talking.
But Detective Gribble, the only information he had is that someone named Mr. Page.
That's because
But he's-
the receptionist doesn't do her job, and nor does OPD. I mean, the information that secretary knows, as far as I'm concerned, that all of OPD knows. When he calls to that secretary and says, I'm a lawyer, I am this person's lawyer, I want to talk to the detective, then by God, every person at OPD is deemed to have that same knowledge. Because we're not going to play compartmentalizing games where the secretary is deemed to have this knowledge and the detective is not deemed to have that knowledge because the secretary didn't tell him. That's a bad road to go down.
Because otherwise, they could have standing orders from the secretary, standing orders to the secretary to say, hey, we're about to interview this suspect, and whatever you do, don't interrupt us. Don't interrupt us, and especially if a lawyer calls.
And isn't that what the Supreme Court said in McAdams? Aren't they making those very distinctions when they talk about, well, we're not just even going to talk about in custody, we're going to talk about this in a global fashion. Aren't we trying to stop those types of distinctions?
Yes, and the state doesn't argue that because a receptionist receives information and keeps it from other detectives, that that's somehow proper. The cases are quite clear that that's kind of imputed knowledge, as Your Honor was saying.
Okay, so then your detective is aware that an attorney is calling under the imputed knowledge doctrine.
Well, the state's position is that
Isn't that what you just said? No? Okay, go ahead, finish.
the state's position is that in this case, we have Mr. Page testifying that he spoke to an unidentified person, that he told this person that he was an attorney. That message was not conveyed to Detective Gribble.
You just said that really doesn't matter because Detective Dribble is now on notice of that.
As an attorney,
What
but
else?
he's not invoking anything, and he's not trying to speak with the defendant. He's trying to speak with Detective Gribble.
But just as Judge Cohen said, he's unlikely calling to see whether his day is going all right. Wouldn't that desk officer have an obligation to go back and knock on the door and say, Detective Gribble, there's a lawyer on the phone that wants to talk to you, and I think it's about the guy you're questioning?
I don't believe so, not in this case, Your
Well,
Honor.
it says in McAdams, under the interpretation of the Due Process Clause of the Florida Constitution we adopted today, which is a few months ago, it is the individual, Mr. Greenwich, rather than law enforcement, who's given the knowledge and power to decide whether to take advantage of the attorney's services. So Mr. Greenwich here wasn't given the knowledge and power to take advantage, if he elected to do so, of the fact that there was an attorney on the phone for him.
But again, Mr. Greenwich...
Isn't that dispositive right there, black and white, bright
Not in
line
this
rule
case,
that
Your
they
Honor.
talk, not dispositive?
Not in this case.
Okay.
Mr. Greenwich knows his stepfather. He knows his stepfather's an attorney. At the suppression hearing, he's testifying, I wanted to talk to my mom because I wanted to talk to my father, my stepfather.
All right, thank you, Counsel.
We request this court affirm. Thank you.
Does that mean we're supposed to leave the building?
I can see where the court's going, so I'm going to be very brief. My whole purpose...
Oh, don't think you ever can assume where we're going. We have no idea where we're going.
Absolutely. I just want to clear up one thing and make one further point. That's something Judge Lemonitis just brought up. On page 94 of the motion to suppress, which would be 334 of the record, it actually is cleared what Mr. Page called for. He was asked, did you leave a message with the Orlando Police Department that you are a criminal defense attorney or an attorney in any fashion and that you wanted to communicate with Reginald Greenwich? That's the information that I gave the receptionist when I asked for the detective. So whether or not, oh, this and that, he was given the information that he wanted to talk to Mr. Greenwich. And as Judge Lemonitis stated, this is not just the detectives didn't know. This is a willful ignorance of Detective Gribble. He's given pages by the comm center. He's left a voice message that says, I'm an attorney.
Well, I mean, to his defense, I mean, he's not given any information from the comm center that there's an attorney on the phone. He's given information that the guy's stepfather is on the phone. He doesn't, that doesn't mean he has to stop everything, and the fact that he didn't answer his voicemail.
The Supreme Court has said in McAdams, the police cannot refuse to interrupt an interview when it comes to this due process violation.
I know, but you're saying that the detective knew that. I mean, under imputed knowledge, he knows it, but personally, I mean, the big beef that we have here is that the receptionist or the dispatcher was aware and didn't communicate that to the detective.
I agree with that, but my belief is 6 times before a 20-minute break was taken, that phone buzzes. One time it buzzes so much that even Mr. Greenwich comments to the detective, hey, your phone's ringing, and he chuckles. What's stopping him from, during that 20-minute break that they took, from checking his voicemail then? Had he checked his voicemail then, during his own break of the meeting, he would have gotten that message and he could have contacted Mr. Page. That is a willful ignorance of Detective Gribble. And that, I would argue, isn't just mere this receptionist not giving the information. This is the detectives willfully ignoring his pages. He could have made a call during that break. He could have checked his voicemail during that break, and he did neither. That is willful ignorance of Detective Gribble, who, for most of that 4-hour interview, sat in the back fumbling with paper.
So if I'm getting texts now here, and if we take a break and I don't want to answer my text in the first 10 or 15 minutes, I'm willfully ignoring my text?
If you're a detective conducting an interview and one of those texts is, this person wants to contact you in regards to this case, yes. I believe that would be a due process violation under Article 1, Section 9.
Why doesn't the stepfather have an obligation to advise specifically, I want questioning to stop?
I believe he did in that, but
He did not specifically say that.
common sense, as this court has said, dictates he's not going to make the effort he made in this case, calling 2 different agencies, calling repeatedly, just to say, hello, how are you doing today? By the way, we've never met. I'm Mr. Page. You're interrogating my stepson. Have a good day. Enjoy your
But
interrogation.
wouldn't it make sense for him to call and say, I've been trying to get in touch with this lawyer, with this detective. I want him to stop questioning my stepson immediately.
I absolutely agree with that. However, as Justice Cohen referred to...
I'm not justice, and I don't even want to ever be a justice.
As Judge Cohen referred to
And none of us want him to be either.
State v. Allen, if you read State v. Allen, that was a workers' comp attorney calling, and all he did was ask for the detective. The evidence, as it's put in the opinion, it's not very clear that he did anything more than that either, and the first reversed in Allen. So I believe that this should be reversed and remanded for a new trial.
All right, thank you.
Thank you, and have a nice day. Thank you.